Welcome to BusinessTraining.com. This video module is designed around background checks. This is our agenda for the video topic today. Please take a moment to review the outline. Employers conduct background checks for a number of reasons. Background and credit checks are a common employment screening method being used more and more today. Employers are doing these screens for a number of reasons, to include, but not limited to, the safety of the workplace to avoid negligent hiring by verifying information or doing character checks, verifying the right to work within the United States, whether as a citizen or with a visa, and verifying information that is provided on a resume to avoid false or inflated information provided by applicants. These checks are done to protect the employer from hiring an employee that is not a good fit for the position and to also avoid the possibility of problems that may arise from the candidate in the future. The level of background checks will vary by employer, ranging from verifying a social security number to doing a full investigation with character references and work history verification. Conducting background and credit checks falls under the limitations of the Fair Credit Reporting Act and the Fair and Accurate Credit Transaction Act, or FACTA. As stated, the level of background checks may vary and may include things such as driving records, credit records, past employers, education records, or character references, among other things. Background checks can be conducted by in-house personnel of the company or by a hired third-party investigator. The Fair Credit Reporting Act sets national standards for employment screenings, which only applies to third-party investigations of background checks that deal with an applicant's credit standing or capacity, character, general reputation, or personal characteristics. The definition and language is broad, but it defines a background check as a consumer report which falls under the jurisdiction of the FCRA. There is also an investigative consumer report, which provides information on an applicant's general character or reputation by an agency gathering information through personal interviews with neighbors, friends, or acquaintances. Employers are required to obtain written consent and authorization from the job applicant to conduct searches into the background of the applicant, such as for credit checks or medical records. Certain topics are not required to obtain written consent, such as for driving records, which are not confidential, and military records, which can disclose name, rank, salary, assignments, and awards. Under the Fair and Accurate Credit Transactions Act, employers are not required to obtain permission to conduct an investigation of suspected employee misconduct. For investigative consumer reports, employers must disclose in writing to applicants that a report is being requested containing information about their character, reputation, personal characteristics, and mode of living. Employers must ensure this disclosure includes a statement that applicants are entitled to request information about the nature and scope of the investigation, and they must receive the disclosure no later than 3 days after the report is requested. The disclosure must also include a summary of the applicant's rights under the FCRA. Employers are also required under the Fair and Accurate Credit Transactions Act to ensure the prevention of identity theft, such as protection of Social Security numbers, or providing no more than 5 numbers of credit card numbers, as well as providing the proper disposal of confidential records. There are certain items that cannot be reported by reporting agency to employers. Any civil suits or civil judgments and records of arrest from the date of entry of more than 7 years ago are not reportable. Paid tax liens or accounts placed for collection after 7 years are also not reportable. Any other negative information, except criminal convictions, is not reported after 7 years. And finally, any bankruptcy over 10 years is also not reported. Some states only allow conviction, not arrest records, to be reported. These limitations do not, however, apply to jobs with an annual salary of $75,000 or more. Employers need to be aware, however, that when using the results of a background check for employment determination, they must be careful not to unintentionally discriminate against applicants. For example, poor credit history, statistically, is more typical of women and minority groups. Some states require that credit history be directly related to the job, such as in handling money of transactions, rather than determining an applicant's reliability. Medical records cannot be requested and used as a basis for employment unless the information is relevant to the employment. If an adverse decision not to hire an applicant is made based in part on a consumer report, employers are required to notify the applicant of the decision not to make the job offer, and they must supply the name and contact information of the credit reporting agency that was used. The employer must let the person know that it was the employer, and not the agency, that made the decision and that he or she has the right to dispute the information in the report, as well as having the right to require an additional free copy of the report within 60 days. Can an application ask about things that are reported under the FCRA? The FCRA does not prohibit employers from asking questions in an employment application. For example, an employment application might ask if an applicant has ever been arrested, where the FCRA says a consumer reporting agency cannot report an arrest from the date of entry more than 7 years ago. Some states, however, may limit the questions an employer may choose on a job application. Are there flaws or loopholes in the FCRA? Yes. The FCRA has two significant loopholes. The first is if the employer does not use a third-party screening company. They are not subject to the notice and consent requirements of the FCRA. Second, the employer might tell the applicant that they were rejected based on that there are too many exceptional applicants in the job pool and not based on the contents of the background investigation. Can an employer continue to check an employee's credit after they have been hired? Yes. The FCRA allows employment background checks not just for employment purposes, but also for promotion, retention, or transfer. Once permission has been given, it generally does not need to be given again. If information on background checks is inaccurate, what can a job applicant do, and is the employer required to re-extend a job offer? If there is inaccurate information on a background check, the applicant should file a dispute in writing with the company that prepared the report. The company then has 30 days to investigate the dispute and give written notice to the person no later than 5 business days after the investigation is complete. The applicant should go to the source of the error and fix the inaccuracy. However, an employer is not obligated to act upon a corrected report and reinstate a job offer. If you would like more information on background checks and the Fair Credit Reporting Act, please visit any of the following websites. Thank you once again for your time and attention, and this is businesstraining.com, where you can earn a master's level qualification to make more money.